The National Constitution Center presents Constitutional Questions with Supreme Court Justice Neil Gorsuch, the Bill of Rights. Philadelphia, September 1787, the Constitutional Convention. As the framers are putting the final touches on the Constitution, George Mason, author of the Virginia Declaration of Rights, suggested that they add a Bill of Rights. Tired and hot, the delegates said no, and Mason refused to sign the document. Even James Madison, who many refer to as the father of the Constitution, didn't think that a Bill of Rights was necessary. He thought that the Constitution's structure, including its system of checks and balances, would guard the people from abuses by the new national government and protect their rights. However, following the battle over ratification of the Constitution, Madison changed his mind. During the ratification debates, one of the Anti-Federalists' most powerful arguments for opposing the Constitution was that it didn't include a Bill of Rights. And even though James Madison and his fellow Federalists eventually secured the ratification of the Constitution, the first Congress turned to the task of adding a Bill of Rights to our nation's charter. Madison himself took the lead, drafting a Bill of Rights and securing its passage in the Federalist-controlled First Congress. The Bill of Rights, our nation's first 10 amendments, was ratified on December 15, 1791. And now, let's hear more from Supreme Court Justice Neil Gorsuch on the Bill of Rights.
I think what Madison thought was that the Constitution as written made sense, and that it was inherent in the idea of the vesting clauses. Madison also thought that the Bill of Rights wasn't necessary because he thought those interests would be protected by the separation of powers. You don't need to assure specific liberties if you have a lawmaking process that's going to respect minority rights. That's what the Bill of Rights is all about, is protecting your rights when you're not popular. If you're popular, who needs the Bill of Rights? You win. It's when you're unpopular. And Madison knew that in the long run, there are going to be times when each of us may be in the ascendancy, may be in the minority. And that's what the Bill of Rights is for, but he also thought, he really thought, that if we got the design of the Constitution right, that those minority interests, due process, equal protection values, would be respected for all persons. And in fact, we know this to be true, though, Jeffrey, don't we? I mean, there are a lot of excellent bills of rights around the world. My favorite is North Korea's. North Korea has a most excellent Bill of Rights. You know, and some of your students will appreciate that it even guarantees you constitutionally protected right to relaxation. I'm not kidding, it's there. And the inviolability of all persons. Well, now how does that work out in North Korea, okay? That Constitution, that Bill of Rights, isn't worth the paper it's written on. And it isn't because Madison knew again that if you put all power in one set of hands, you can write all sorts of nice promises about your rights, but they don't mean anything. The way we protect rights is by dispersing power carefully among the separate branches. That's the genius of our Constitution.